This AI-generated podcast is for general information only and does not constitute financial or legal advice. Listeners should independently verify all information. Please consult a qualified professional.
Welcome to the Luxembourg Fundcast, produced by Bertrand Mariaux, a regulatory lawyer qualified as Avocat à la Cour in Luxembourg and Paris. This show brings you reliable insights on Luxembourg regulations sourced from curated official references. This episode is current as of 14 June 2026.
So, today for our deep dive, we are examining a very specific operational scenario.
Right.
Let's say you have a private banking entity and they're preparing to distribute a newly structured financial product. Capital allocations are projected, the target market is identified, and client interest is confirmed. But then the entire distribution process is halted internally.
Wow. Okay, so everything stops.
Exactly. And the halt doesn't stem from, external market volatility. It comes down to a single missing procedural component, which is an incomplete product launch note lacking a definitive operational sign-off.
Right, because the governance structure requires absolute alignment before distribution can begin.
Exactly.
And that leads us to our core focus today. We're examining the exact regulatory obligations that enforce this strict sequence. So our analysis centers on one primary thesis. In Luxembourg private banking, product approval must structurally precede product launch, requiring explicit documentation of the governance perimeter, compliance, risk, and operational readiness before any new activity is undertaken.
Right. That sequence is an absolute requirement. It's not, a mere operational preference.
No, definitely not. And to execute this correctly, we will structure our analysis around exactly three core takeaways.
Okay.
First, we'll establish the parameters for defining the exact governance perimeter of the firm. Second, we'll detail the rigorous requirement to document the approval decision through formal inputs.
Right.
And third, we will examine the precise regulatory mandate to block early implementation of any new activity. We'll look at the specific legal texts that dictate these standard operational parameters.
So let's just systematically jump right into that first core takeaway, defining the governance perimeter. Because, a firm can't govern a product launch effectively if it doesn't first correctly classify its own regulatory status.
Exactly. You have to map the exact nature of your investment services first.
Right. And the foundational text dictating this classification is the Luxembourg Law of 5 April 1993 on the financial sector, as amended.
Right. And for the purpose of our technical analysis today, we will refer to this legislation as the 1993 LFS Financial Sector Law.
Perfect. So, under this text, Article 1 of the 1993 LFS Financial Sector Law establishes the definitional framework for entities operating within the jurisdiction.
Right.
And it draws the baseline distinction between credit institutions and investment firms, which is, what establishes the specific compliance obligations that follow.
Yeah, and the necessity of that distinction is really apparent when you look at a standard private banking operation. Well, a bank conducting private banking business remains a credit institution legally, even when it provides a wide array of investment services to its clients.
Right, okay.
Therefore, the entity must fulfill the obligations of a credit institution while simultaneously adhering to the operational requirements specific to those investment services. Once categorized under Article 1 of the 1993 LFS Financial Sector Law, it has to rigorously map its specific activities.
And those specific activities, they're classified within Articles 24-1 to 24-9 of the 1993 LFS Financial Sector Law.
Exactly.
These articles identify the investment service categories relevant to investment firms and credit institutions acting in similar capacities. And I really want to examine those classifications closely because the procedural depth varies based on the interaction. Articles 24-1 to 24-9 of the 1993 LFS Financial Sector Law cover services, including investment advice, portfolio management, and the reception, transmission, or execution of orders.
So, why does distinguishing between these services actually matter for product governance? I mean, are the obligations identical whether a firm is merely executing an order versus providing active portfolio management?
Well, the baseline governance requirements apply to all of them, but the procedural application differs significantly based on the level of interaction with the client and the instrument.
Okay.
If a firm provides investment advice under the categories listed in Articles 24-1 to 24-9 of the 1993 LFS Financial Sector Law, it actively directs a client toward a specific financial instrument.
Right.
That requires a documented understanding of both the instrument's risk profile and the client's specific financial situation. And if the firm conducts portfolio management, it makes discretionary investment decisions on the client's behalf, which requires an even broader mandate of ongoing suitability assessment.
Right.
But what if the firm solely handles the reception, transmission, or execution of orders?
Well, in that scenario, the firm facilitates a transaction without necessarily providing personalized advice. However, regardless of the specific service identified in Articles 24-1 to 24-9 of the 1993 LFS Financial Sector Law, the firm must integrate that activity into its product governance framework.
So they can't just opt out?
No, the firm cannot claim exemption from governance parameters simply because it executes an order rather than advising on it.
Right, and that leads directly to the core operational obligations regarding the financial instruments themselves. This is detailed in Article 37-1 of the 1993 LFS Financial Sector Law, which applies to credit institutions and investment firms when they manufacture, offer, or recommend financial instruments.
Right. Product governance hinges directly on the firm's relationship to the instrument in question. The regulation acknowledges three distinct operational situations under Article 37-1 of the 1993 LFS Financial Sector Law. First, the firm manufactures the financial instrument directly, meaning it creates, develops, issues, or designs the product.
Okay.
Second, the firm offers or recommends a financial instrument that it does not manufacture. And third, the firm combines both roles within its service offering, manufacturing certain products while distributing others originated by third parties.
So they just need to figure out where they sit.
Right. The firm must accurately map its activities to one of these three situations to ensure its protocols align with the regulatory standard.
Well, I want to challenge the practical application of that second scenario.
Okay.
Suppose a private banking entity merely recommends or distributes a fund unit manufactured by a completely independent third-party asset manager. The private bank had no role in designing the fund, structuring its internal risk parameters, or defining its investment strategy. Does that distribution activity strictly fall within the governance perimeter under Article 37-1 of the 1993 LFS Financial Sector Law?
Yes, it absolutely does. Recommending or distributing financial instruments legally positions the activity squarely within the product governance perimeter. You cannot separate distribution from governance.
Okay.
A firm offering instruments it does not manufacture cannot bypass governance requirements by just pointing to the originator.
But what if, even if the third-party manufacturer has already performed its own rigorous product approval process before releasing the fund unit to the market?
Even then, the distributing entity cannot rely solely on the manufacturer's internal process. Under Article 37-1 of the 1993 LFS Financial Sector Law, the distributing firm must obtain all necessary product information directly from the manufacturer.
Oh, I see.
Furthermore, the distributing firm must explicitly understand both the specific characteristics of the instrument and its identified target market. These are standard operational parameters. The entity cannot claim ignorance of the product structure or potential risk under market stress simply because a third party originated it.
So therefore, the governance perimeter is absolute and continuous.
Yes.
It encompasses the manufacturer who designs the product, and it extends fully to the distributor who presents it to the end client. Both entities share responsibility within their respective operational spheres.
Exactly.
And this brings us to the second core takeaway: the formal documentation of the approval decision. This phase transitions the firm from theoretical categorization to concrete operational evidence.
Right, and this transition introduces our primary thesis for the second time. In Luxembourg private banking, product approval must structurally precede product launch, requiring explicit documentation of the governance perimeter, compliance, risks, and operational readiness before any new activity is undertaken.
Right. And the product launch note is the formal manifestation of that exact requirement.
Yes, it is.
So let's detail the obligations of a manufacturing firm first, just to understand the baseline requirement. A firm that manufactures financial instruments for sale to clients must maintain, operate, and review a product approval process.
Correct.
And this process must be fully executed before the financial instrument is distributed or marketed to any client. The process itself must be formalized and systematically auditable.
Right. And for both manufacturers and distributors, the formal output of this rigorous process is the product launch note. The product launch note is the internal evidentiary document mandated under Article 37-1 of the 1993 LFS Financial Sector Law.
Okay.
It records the definitive completion of the approval process. The note must explicitly record three critical elements. It must contain compliance input, risk input, and confirmation of operational readiness.
So we should examine those inputs clinically. In standard operational parameters, compliance and risk departments frequently collaborate, but how do their specific inputs differ within the context of the product launch note?
Well, they serve distinct, specialized procedural functions.
Okay.
Compliance input requires a formal assessment by the compliance function, confirming that the product, its legal structure, and its intended distribution strategy adhere strictly to all current regulatory requirements and the firm's internal policies. It verifies absolute legal conformity.
Right.
Risk input, however, requires the risk management function to mathematically quantify and document the actual risk profile of the instrument. The risk function must ensure that this identified risk profile aligns with the firm's overall risk appetite and the specific risk tolerance of the intended target market.
Okay, so that leaves the third element, which is operational readiness. This appears to be the phase where theoretical compliance meets practical execution. So, what specifically must be verified to achieve and document operational readiness?
Operational readiness requires verification that the firm's internal infrastructure can physically and technically support the life cycle of the product.
Okay.
The documentation must clinically demonstrate that the firm comprehends the required operational capacity to support the launch. This involves confirming that the IT systems can seamlessly process the specific type of transaction, the accounting systems can accurately record the asset valuation, and the reporting systems can capture all required data points for subsequent regulatory filings.
All right, well, let's consider a procedural discrepancy.
Right.
What happens in a scenario where a firm has obtained formal compliance and risk sign-offs for a complex new derivative product, but discovers during system testing that its internal reporting software cannot capture a specific data point required for that derivative?
Right.
How does the requirement for a product launch note function to prevent the firm from simply proceeding with the launch while the IT department works on a patch in the background?
Well, the product launch note functions specifically to prevent that exact scenario. It acts as the definitive integrated record. It ensures that compliance, risk, and operational inputs are consolidated into a single document.
Because you need all the signatures in one place.
Exactly.
Right.
By requiring explicit, documented sign-off from all three departments within one note, the protocol prevents departments from operating in isolation or approving partial readiness. If operational readiness is unverified because an IT system cannot process the required data point, the operational department cannot provide its signature.
Right.
Consequently, the compliance and risk functions cannot provide their final sign-offs, and the launch note cannot be finalized. The mechanism mitigates the risk of operational gaps before any distribution occurs.
And this precise integration of departmental inputs leads directly to our third core takeaway, which is blocking early implementation. The inability to finalize the launch note directly triggers the regulatory mechanism that blocks the product from going live.
Yes.
The finalized product launch note from Step 2 is not merely an archive checklist. It is the precise evidentiary document required by authorized management to unblock the final stage, which is the actual implementation of the new activity.
Right. And to analyze how this blocking mechanism functions procedurally, we have to consult the administrative circulars issued by the financial regulator. For credit institutions, the governing text is Circular CSSF 12/5552.
Okay, and we will establish the shorthand for this text as the 2012 CSSF Credit Institutions Circular.
Perfect. And we must also examine the parallel regulation dictating the requirements for investment firms, which is Circular CSSF 20/758.
And we will establish the shorthand for this text as the 2020 CSSF Investment Firms Circular. Both texts contain explicit directives on how authorized management must govern the initiation of new activities.
Exactly. The regulatory standard is established in point 183 of the 2012 CSSF Credit Institutions Circular, which applies to banks active in private banking. An identical procedural standard is set forth in point 180 of the 2020 CSSF Investment Firms Circular.
So point 183 of the 2012 CSSF Credit Institutions Circular and point 180 of the 2020 CSSF Investment Firms Circular establish a strict, unconditional mandate.
Right.
They state that no new activity may be undertaken unless authorized management has explicitly approved it. Furthermore, the texts stipulate that all relevant parties must have been formally heard and the required means must be available. Let's unpack the exact procedural meaning of those three conditions.
Sure. So the first condition, requiring that authorized management has explicitly approved it, means that the management board, or the equivalent governing body, has reviewed the fully finalized product launch note and provided a documented formal decision to proceed.
Okay.
The second condition, ensuring that all relevant parties have been formally heard, refers directly to the documented compliance, risk, and operational inputs we previously analyzed. Their signatures on the launch note serve as proof that they were formally heard.
And the third condition, stipulating that the required means are available, strictly reinforces the operational readiness component.
Exactly.
The firm must possess the necessary human resources, technical IT infrastructure, and procedural frameworks to support the activity before it begins.
Correct. And this leads to the absolute reinforcement of our primary thesis for the third time. In Luxembourg private banking, product approval must structurally precede product launch, requiring explicit documentation of the governance perimeter, compliance, risk, and operational readiness before any new activity is undertaken. Approval comes first. Launch comes last. The regulatory sequence cannot be inverted.
Well, I want to scrutinize the definition of early implementation. Does this regulatory block apply exclusively to the formal launch date and the execution of live trades, or does it also restrict preparatory activities that occur prior to the launch? Consider a scenario where a firm intends to launch a new product in 30 days. The product launch note is drafted, but awaits the final management signature. To prepare the market, the distribution team sends informational brochures regarding the product to a select group of existing clients. Does this constitute early implementation?
Yes, it does. Initiating any operational or client-facing activity prior to explicit authorization from management constitutes compliance nonconformity. The block is absolute until the required means are confirmed available and management has explicitly approved the new activity based on the finalized product launch note.
Wow, so the regulatory block applies strictly to preparatory actions as well.
It applies to all initiations of the activity. Early implementation actions could include setting up live client accounts specifically coded for the new product, executing preliminary trades to test settlement pathways, or, as you suggested, distributing marketing materials to clients before the authorized management has signed the product launch note.
Right.
All such actions are strictly prohibited under Point 183 of the 2012 CSSF Credit Institution Circular and Point 180 of the 2020 CSSF Investment Firms Circular.
The technical implication here is significant for IT and systems architecture. Firms cannot rely solely on verbal instructions or internal procedural memos to prevent early implementation. They must design their internal IT systems and operational workflows with hard systemic blocks.
Absolutely.
For instance, a trader should not physically be able to route an order for a new financial instrument in the core trading system until the compliance department lifts the systemic block. And the compliance department will only lift that block upon receiving the fully executed product launch note signed by authorized management.
That is the correct procedural interpretation of the texts. The documentation requirements under Article 37-1 of the 1993 LFS Financial Sector Law mandate the collection and synthesis of the necessary data.
Right.
The management approval required by Point 183 of the 2012 CSSF Credit Institution Circular and Point 180 of the 2020 CSSF Investment Firms Circular provides the formal authorization to proceed. Without both the complete data and the explicit authorization, the operational block must remain fully active.
So, to ensure strict conformity with these regulations, every private banking entity must meticulously evaluate its internal protocols regarding these sequential steps.
Yep.
You must define your governance perimeter based on your exact activities and the nature of your investment services under the 1993 LFS Financial Sector Law.
Yep.
You must document the approval decision through a rigorous product launch note containing comprehensive compliance, risk, and operational inputs. Finally, you must implement strict systemic mechanisms to block early implementation until authorized management grants explicit approval based on the requirements of the circulars.
We suggest you review your firm's internal protocols. Consider how your current product launch notes document the synthesis of risk and compliance inputs and assess whether your internal workflows strictly block operational implementation until authorized management provides explicit documented approval. Verify that operational readiness is fully confirmed before any systemic block is removed.
Follow on Apple Podcasts, Spotify, or wherever you get your podcasts. Listen also to the French edition of the Luxembourg Fundcast.
Subscribe to Bertrand Mariaux and Rigore Media on YouTube. Connect with Bertrand on LinkedIn. Read the full analysis of the podcasts at bertrandmariaux.com, all links in the show notes. This was the Luxembourg Fundcast.